Thank you everybody for watching. And today we are joined by Arash Zad, lawyer based out of Dubai, and by Firas Al-Masaddi, founder and CEO of FAM Property. Gentlemen, thanks for joining.
Thank you for having us. Thank you for having us.
So guys, some of the hot topics today is when it comes to buying property from developers, off-plan specifically. There's a few other things that we're going to talk about, but I want to get into some of the hot topics. And what we've done is we've taken a few questions that have come in via social media, via email. So I'm going to want to understand your perspective, Arash, from a legal perspective, and then Firas from a commercial perspective as well. So the first question that has been asked repeatedly, in fact, is if a developer has sold an off-plan property as a hotel apartment, can they then change it to a normal residential apartment? And this question has come in about 6 times from across the country. So from a legal perspective, let's start with Arash.
If a property has been sold on hotel apartment basis, it means that the permitted use of this property has been announced and has been documented as per the sale and purchase agreement. The buyer and the investor, obviously, based on this understanding, is committing to sign the contract. And definitely when you are signing a contract, you know what is it that's going to be delivered to you at the completion date. Based on this, you will agree to pay a certain amount, which is your selling price. Obviously, all these commitments happens based on a certain understanding that you will receive a hotel apartment at the completion date. Definitely, when the property needs to be handed over, it has to be handed over as promised, as a hotel apartment. So therefore, the developer cannot solely at their sole discretion change the permitted use of the property unless if they collect consent of the property owner.
Okay, so the answer to that from a legal perspective is clearly a no. The developer cannot change the description or the unit from being hotel to residential. The answer to that is simply a no.
It's no, unless if they have a consent letter signed by the investor.
Okay, so now that's the next question that's actually come in. Now, can the developer actually force or pressure the person into signing a consent letter? And by the way, Firas, if you have any questions, feel free to jump in on this. But we'll also come to you from a commercial perspective. But can the developer actually pressure or push somebody into signing a consent letter or an agreement?
So we are saying consent letter, yeah? It's not a force letter.
Right.
So of course, developers should not and is not allowed to pressurize or force investors to sign the consent letter. This will be in a form of addendum. It will be in a form of amendment to the SPA, where both parties have to amicably agree on a certain term in order to change the permitted use.
Fair enough. Now, Firas, from more of a commercial perspective, how does this affect the buyer? Let's say the buyer signs a consent form and says, yes, I will do this. What should the buyer look out for from a financial perspective? I mean, does it help them? Does it affect them negatively, positively? Tell us more about that.
Definitely, even from the sound of it, you don't need to have so much real estate experience to figure out that a hotel apartment, from the sound of it, is more expensive and more costly than just a plain residential apartment. So definitely, if I paid for a hotel apartment and now I'm receiving a residential apartment, definitely I'm going to be suffering a loss. I would say this can be anywhere between 15 to 20, even 25%. But what matters most when it comes to the commercial aspect of this, Omar, is what type of property has been delivered. And this is probably a question back to Arash on this. I mean, you know, why would developers change from a hotel apartment or ask investors to change from hotel apartment into a plain residential apartment? What would be their legal motive? I mean, definitely it is to do with protecting or restructuring, you know, the legal ownership of these properties. What would be their motive, in your opinion?
It will be difficult to understand, considering that we are talking in general and not any specific development. It depends on what is actually going on in the current situation, what is in their mind. We can definitely not predict that. However, it could be certain commitments that it has been stipulated in the agreement that the developer won't be able to uphold in terms of delivery at that condition, or perhaps if the developer has accepted or it's obliged as per this SPA to operate that property on hotel apartment basis. So if the cost of operating this has to be borne by the developer, and now considering the current situation and circumstances that we are in, it will be a heavy burden for them, then they might come up with this idea of changing the permitted.
What about the VAT? What about the VAT aspect? Because hotel apartments are subject to VAT being a commercial property.
That was actually something else I was going to ask. Sorry to interrupt, because we did have a question talking about this does affect the tax structure on the actual properties. So yeah, thanks for mentioning that, Firas.
A property, when you are investing in a property, as per the UAE law, if it's a residential property, there is no VAT involved. If it's a commercial property, then there is a VAT involved. You need to pay VAT to the government. An individual who purchased a property based on commercial basis, a hotel apartment, for example, they are obliged to pay the VAT at the end of the day. But now there are many small details here for us and Omar that you need to pay attention to. Number one is that when you are buying this property, when you are paying for this property, and when this property is supposed to be handed over, all these answers will determine whether you are entitled or obliged to pay the VAT or not. And then if the agreement is silent on who will be paying the tax or VAT, normally the developer has to pay the VAT, okay? But if it's clearly stipulated that the buyer has to pay the VAT, in that situation, in most cases, the buyer has to pay at the end of the day. However, one important part here is, it's when we are talking about delayed project. If we have delayed projects, and those projects were supposed to be handed over many years back, we didn't have any VATs at that days.
So if the project was due for handover and for completion prior to 2018, I think the VAT came into effect in 2018, right?
1st of Jan 2018, yes.
Yeah. So let's say that I invested in a real estate project that was supposed to be handed over in say 2016 or 2017. And then the developer delayed the handover. And my agreement says that I am responsible for the VAT, being the buyer, the investor. But because of the delay, I mean, if the developer handed over on time, I would not have to pay VAT because it wasn't subject to VAT to start with. Who's in this case? Can investors claim back VAT from developers, or how does it work?
We have two elements here. Number one is the SPA, which clearly says that the buyer has to pay. And then number two is the developer's delay, which directly affected this matter and implemented the VAT in this situation. In this scenario, I would say that the investor has the right to go against the developer and ask the court to force the developer to pay the VAT, considering that developer's delay caused this damage to the investor.
Sorry, I'm going to jump in with another question that we had come in. In the event the developer actually changes the overall description of the units from a commercial to residential, or vice versa, whichever the case might be, in this event, can the investor or the real estate buyer file a lawsuit against the developer?
And I think most importantly, Omar, what are the chances of them winning these cases? I mean, I know it is circumstantial to a certain extent, but in general, how solid is the stand of the investor?
In terms of the VAT only, you mean?
Yeah, in terms of filing a law case, basically, against the
because
developer to claim the VAT back.
There are many aspects that could cause a potential case against the developer. Number one is the delay in handing over. So we have to see that how are we going to present our lawsuit? In my experience, the way that we do it, in some circumstances, we have the chance to claim many things under one case, rather than just going for one claim. So in situations like that, if you are just purely going for VAT, I think that they have a good case. We can definitely not guarantee the outcome, but it's a common sense as well. If the project was handed over on time, I was not forced to pay VAT. So therefore, this delay has caused me this damage. Therefore, I will ask the court to enforce the, to force the developer to pay the VAT.
Another question I want to ask Arash from a legal perspective, and it also has a commercial aspect to it. In the event these things do take place, the developer does change the overall description of the unit from residential to commercial or vice versa, any changes are applied, can then the investor or the real estate buyer ask for a refund? And what are their chances of actually getting a refund? Also, do they have to take a legal route for this? Or
I mean, a refund on the property price.
A refund on the property, correct.
You know, in the market, I would just add to the same question as Omar I just asked. So basically now I am part of a project, right? So I bought one apartment in a building that has probably 200 apartments. Yeah. What is my stand if everyone actually signs on the consent of turning it from a hotel apartment into a residential apartment? I think probably that is the context Omar was referring to. So can I go and say, I didn't sign, give me a full refund of my property price?
Well, I will answer your question by sending another question to you. Did that individual sign a contract in a group format with a developer? Or he signed individually?
So let's say he wasn't part of a group format.
I know, I get you. There is no group sale and purchase agreement. Every single individual has signed individually. Unless they get a consent from everyone, every single individual that did not give consent to this permitted use has the right to ask for damages.
Yeah, but the question is the developer going to turn one unit by one unit from on the title deed from being a hotel apartment into a residential apartment, or actually the developer will have to turn the entire building, which means it's like a blanket approach that would apply to every single owner in that building, not just to the 190 owners that signs.
Yeah, with that procedure, we need to double check with land department and see what are their requirements to change the permitted use. What I understand, I think they require, I'm not sure, we need to double check. But I'm assuming that they need a certain number of units in one project to give consent to this change.
Exactly. So what is the stand of the investor that didn't sign, wasn't part of the group of investors that signed on the consent?
Still, that person can
ask for a refund?
No, refund definitely no. This is not a good ground for asking for a refund. Most what they can is to ask for compensation. Because as you clearly mentioned, there is a big change in the value of the property, and that can be claimed from the developer.
So Arash, really important question here. Now, if I buy a hotel apartment, and on my title deed I have a hotel apartment.
Yes.
Okay. Does that mean that my property, the developer has built a property or a project in line with DTCM, Dubai Tourism Department? Because what I heard as well from the market that there are hotel apartments projects that are not in compliance with DTCM, but yet there are hotel apartments on the title deed, but DTCM did not give the permission because they're not in compliance when it comes probably to the quality or the provisions available in that project.
That's a very good question for us. So let me put it this way. In order for you to get your completion certificate, you need to be up to the standards which has been required for a certain type of property. So if you are building a hotel apartment, you need to build as per the requirement of a hotel apartment as per the current rules and regulations. What you need to consider here is that we have different grades in terms of 2-star, 3-star, 4, 5 stars. And it could be in different levels or different grades, yet they are qualified as a hotel apartment. When this will be an issue, when this topic will be very important, is that an agreement has already confirmed the specification of this property, which will be handed over to them in time as a hotel apartment. So these specifications are a specification of a hotel apartment. So it's a very good point, yeah, that you raised. So if a developer had in mind to hand over a property on residential basis, yet on the paper is a hotel apartment, so most probably they will build as per a normal residential apartment, not as per a hotel apartment.
Because they got paid as a hotel apartment, so they sold at the higher end of the price, definitely.
Well, this will be more in favor of the investor in order to sue the developer, you know? Okay. So definitely this is something that has to be carefully studied, case by case basis, to see what exactly has happened here.
Have you experienced such cases?
We had. So normally what we do is that when we file the case, the court will appoint an expert who is fully aware of the requirements, specifications, and all the single details of a hotel apartment. Then that expert will go and do the investigations on the site itself, and they will check out the property. They will see that whether this property has been built on hotel apartment basis or it's just a normal residential apartment. Then what you mentioned is that they will figure out how much of a change has been applied here. Right. How much of a devaluation has happened here. So based on that, they will prepare their report and they will say that, okay, the investor has the right to claim compensation up to this amount.
So let's say that Omar bought a property from a developer, okay, off plan.
Yeah.
And then I came to buy the property during the construction from Omar. So Omar is reselling the property to me before the property being handed over.
Okay.
Now, in my commercial understanding, I should be inheriting the same SPA, the same completion date, basically clauses of the agreement that he bought on from the developer. Can the developer change the SPA? Or does Omar have the legal right to tell the developer, no, I bought from you based on 1, 2, 3. You cannot change the SPA because obviously the marketing comes before the execution of the legal aspect of any sales and sales transaction. So Omar has already convinced me to buy based on a certain completion date. But in some cases, when Omar goes to the developer to get the NOC, the developer would change the completion date from, for example, 2016 to 2018. So the new buyer, being me, will have no right to talk to the developer if the developer was delayed to hand over.
To answer this question, I'll answer it in two different scenarios. Number one is that what you are saying is absolutely common sense and a fact that when you buy something, you bought it under certain terms and conditions. And when you want to sell it, you should be able to sell it under same terms and conditions, especially considering that the property has not been still handed over. Yeah, so it's the same situation as the time that you have purchased it. So then yes, the developer should not change. However, I have reviewed few or more than few sell and purchase agreements, and I see that most of the developers put some clauses in their agreement which exactly attacks this point and says that if you as a buyer want to sell this property, you have absolutely no rights to object on changing certain terms and conditions of this agreement based on your SPA. You cannot demand to have the same thing for your buyer. If you have signed an agreement with such clause, you have already lost your right to claim anything against the developer. That's one important point.
Wouldn't the court look at this? I mean, at the end of the day, I think if the contract was very much one-sided agreement, then don't courts have like a different stance sometimes? Or you think that it's a very poor legal ground for any investor to go after the developer in that sense?
Well, I would advise not to if they have signed. The reason is that the judge will ask you one question: did anybody force you to sign this agreement?
Yeah, exactly.
So we are required to study the agreement before we sign it, understand all the terms and conditions of that agreement, and if we are happy with it, then we sign. If we sign, it means that we have no objections toward it. So definitely the judge will not look into it.
Gentlemen, once again, thanks a lot for being here and for giving us the time today and for answering the questions. Firas, founder and CEO of FAM Properties, and Arash Zad, real estate lawyer based out of Dubai for 15 years. Gentlemen, if anybody has any questions, whether from a commercial perspective or legal perspective, how can they reach out to you? Firas, what would be the best channel to reach out to you?
They can drop me an email at any time at ceo@famproperties.com.
And do you actually get back to people on this email?
Yeah,
fair enough. That's good to know. And Arash, how could people reach out to you for legal advice?
So they can send me an email to arash@zadlaw.com, or they can find me on all social media platforms under Arash Zad, ARASHZAD, on Instagram, LinkedIn, and everywhere else.